want to represent her because you can't believe that she's this bad, then you need to just drop off the case and go work your Merc trial and get the hell on. That's it, period. Or he should be questioned. This is ridiculous. So, now here's the new complaint. I'm only going to read the part about, I'm only just going to go over the part about the charge of the young lady that was unlawfully detained and the uncle. All right, because we're hitting an hour and 23 minutes with this. So, yeah, this is something else. And there's a reason why I'm going into depth about this. You have judges like this sitting on the bench that don't know how to act, and they think that they're impervious to the rule of law. They think they're above it. They think they should not have to answer to anyone. They think they don't do anything wrong when they do many, many things wrong. We went from 17 counts to now 15. A whole new list of charges, 15 more counts to her attorney. That's a total of what? 17, 15, 32? Yeah, no, there are more cases, some of which didn't make the cut when filed to Courtneyville as a complaint. That's going to be refiled. Trust me, there are a lot more victims out there. Fulton County is a very large county. You don't think there's more than 32 complaints out there? 32 charges that can be filed against her for misconduct, ex-parte communication, showing biases, favorable treatment, retaliating, now unlawful detainment. Holy Jesus. June 17, 22, a complaint for divorce was filed in Superior Court of Fulton County. October 25, 23, Williams presided over the final hearing. During the final hearing, the party's 22-year-old daughter, MD, was called as a witness, not a party to the case, a damn witness, just a witness. MD, who had a good relationship with her mother, petitioner, and a strained relationship with her father, respondent, testified that she had gone to respondent's apartment and, among other things, damaged contents of the apartment. MD was seated in the courtroom gallery after evidence was completed and during closing arguments. During petition's closing argument, Williams interrupted because rude, began to talk about MD's testimony and instructed MD to stand up in the gallery. Inappropriate. Williams then instructed a deputy to put MD in custody and bring her to the front of the courtroom. First of all, the deputy should have said, why am I putting her in custody? Based on what charge? Because I cannot participate in what you're about to do that is highly unethical and unlawful. Because no one wants to have a spine and a backbone to one person. Now look, there's a whole charge here. And that deputy will be questioned and brought in as a witness to this. He should be summoned and subpoenaed. If he's not, I don't know what's going on, Courtneyville. This is god awful. After MD was brought to the front of the courtroom, Williams questioned her in front of multiple onlookers. So public shame and humility and embarrassment. You don't think that's traumatic enough? You had her detained and put in cuffs in front of people for no justifiable reason. What was the charge again? You didn't even charge her with contempt. You just did it. Abusing your power that was gifted to you through a democratic process called an election. Because no one had to vote for you. We don't owe you our votes. And since you're so worried about your elections and nothing else, you're not going to be elected again. No, you will not. Bullying from the bench, this is deplorable and disgusting of you. Oh my God. Yeah, I read the previous complaint. This is, I don't know if she can, let me not say that because she might just say, hold my beer, Lady Luck Club. I can get worse. It's shameful. It's shameful. This is why all of YouTube is about to ascend upon you. Kidding me? Now, nothing like court of public opinion to add some pressure, because that's exactly what this needs. For it to move along, Courtneyville. And for you to consider many more victims out there of her biased treatment and misconduct and abuse of power and misinterpretation of law. Just disgusting. Williams asks, so that means that you came here today, you admitted to 20, 30, 35, 36 years. You don't even know. You went from 20 to 36 worth of prison time on this stuff. You're just scaring her. So fear mongering, is that what we do? Is that what judges do? Fear monger? Good grief. Do you understand that? And all for a divorce that had nothing to do with you, right? These are her parents. How does that not affect her? How do you know that? You don't know what she's gone through. That's being so insensitive. It's disgusting. You are some man's daughter too, I'm sure. Then you have a father. You're some woman's daughter. You have a mother. You act like she's not supposed to be distraught over her parents getting a divorce. You have no idea what she's gone through and experienced. Why she might be closer to her mother than her father. I have no idea. Unbelievable. And she's 22, so of course she's gonna stand there and say yes. Would have been like, wait, what? How do you know that? You're not a criminal judge. You're family law judge. Stay in your lane. Williams then instructed the deputy, go show her MD what the cell looks like. He should have said, can't do that. None of the attorneys in the courtroom said, Your Honor, we cannot permit that. We cannot permit that. You're about to incarcerate someone. You're about to detain someone, put them in a holding cell unlawfully. What is the charge here? She's entitled to due process. That's not how we operate here in family court. Even a criminal court judge, except Judge Ur Glanville. Because he was definitely going to put Brian Steele in jail for reasons. Oh, because he participated in the judge participated in the ex parte communication. It's sad that that's the example as the chief judge of Fulton County Superior Court. Judge Glanville showing his bias, character, and failure to remain impartial and participating in the ex parte communication. And then trying to hold the criminal defense attorney in direct criminal contempt of court. And when Ashley Merchant, being the boss that she is, who really should probably be a Fulton County judge here in Superior Court, she would make an excellent judge. She had to come down there and defend Brian. He didn't even want to hear her out. And she's spitting out case law and showing precedents off the top of her head like it's nothing. Like, this is easy for me. Was balling. You know what? If Ashley Merchant decided to go run to be the new Fulton County DA, I would vote for you, Ashley Merchant. I would vote for you. Yes, I definitely would. That 15 minutes of just powerhouse display of intelligence and competency and just being sharp and quick on your feet was impeccable. Well done. I saw that. I actually reacted to it. I have a video on it. But that was well done. Well done, Ashley Merchant. Okay, so she tells the deputy to go show her MD what the cell looks like and told petitioner's counsel to continue her closing argument. But the counsel didn't say, Your Honor, I cannot continue in good faith because you just ordered and instructed the deputy to put her in a holding cell, and we don't even know what you're charging her with. Y'all all attorneys. Then all y'all go to law school? You can't hold one person accountable? So there's no checks and balance in the courtroom. She thinks she's queen. I'm sorry, we don't condone a monarchy or dictatorship or authoritarianism in the United States of America. You can take your ass to England or wherever you want to go for that. You go to Russia. They love dictatorship. But get the hell out of here. You're not queen of the court. We got rid of the monarchy over 400 years ago. It's called a Declaration of Independence. We're not in the mood. This is the democracy here. You were elected, and no one owes you the privilege of sitting in this position. And now you're putting people in holding cells, following along with Christina Peterson, who unlawfully incarcerated a woman over a marriage license. Did you not think that was wrong? And then you turn around and do the same thing? Might be on a lesser scale for less time, but it's still restricting and revoking someone's liberty and freedom. You kidding? Oh, man. The deputy took MD into the holding cell where she remained for approximately 30 to 45 minutes. 45 minutes too long. After closing arguments concluded, Williams instructed the deputy to bring MD out from the holding cell for me, please. Once MD was back in the courtroom, Williams asked, How was that experience for you, MD? MD replied, Horrible. You have no idea what type of PTSD and trauma you invoked upon her forcibly. That was not even based on a law or charge or anything. It was just unlawful and unnecessary. You already scolded her and had her detained in front of the public, in front of onlookers. You publicly shamed and humiliated her because she's upset that her parents are getting a divorce. Williams followed with a lecture that she has no right to lecture nobody. I didn't take you seriously at all. I just literally sat there and said to myself, sitting here misquoting laws and just messing up all over the place. And yet she's under JQC investigation. That's all I kept saying to myself in my head. Followed up with a lecture to Indy about being responsible for her actions, stating that she could use this courtroom experience as a learning lesson to guide you going forward where you can continue to do reckless stuff. While you do reckless stuff, and now you're under investigation for it. And you're going to have to be removed from the bench. There's no way she should be permitted to stay on the bench, or you'll be voted out. Either way, you're going to be gone. We don't care. You're going to go. You got to go. You got to go. Williams then added, let me tell you something. I was a prosecutor for 10 years. Sounds like your campaign video. You should have played your campaign video. You know, that same video I just played in the beginning of mine. Yeah. Said the same thing. It's like auto repeat. I was a prosecutor for 10 years, and let me tell you what I saw over and over again. Girls who came in here with daddy issues, they never even realized they had, but that's how they ended up in certain situations. While you retaliated against a respondent because you gave her business and then thought about just giving custody to the father out of retaliation, not because the law permitted that, not because the evidence showed that that was the best fit. Nope. Nope. Just because you being retaliatory. It's disgusting. And what you chose to do as far as your relationship with your dad, that's on you. That's between you, your dad, and the good Lord. So why did you unlawfully detain her for 45 minutes? You certainly had nothing to do with that. It's between her dad, and the good Lord. So why are you putting her in a holding cell for 45 minutes? Unlawfully. None of the attorneys said, Judge, we cannot allow you to do this. Stop. You're already under investigation. When are you going to learn? When are you going to learn, Super City Girl Judge? We're not supporting this. This is crazy. I'm going to get down to the case here with her uncle. Respondent uncle. Yeah, this is the... Hold on. Okay. Okay, let me go back up because this is it. This is the last one I'm going to point out because you can look at the other previous filing, and it's just more charges of her untimely filing of orders, having people wait months and all this other stuff. This is ridiculous. On April 22nd, 2024, Williams called a Metro Atlanta family law firm and left a message for a specific second-year associate attorney, a specific attorney, who called her back after 5 p.m. on Judge Williams' personal cell phone number, because somehow you still think that's okay to do. Judge Williams did not indicate the reason for her call when she left the message. At the time, the law firm had pending cases before Judge Williams. So that's a conflict. The associate called the number provided by Judge Williams and left a message. Judge Williams called the associate back shortly after 6 p.m. and the call lasted for approximately 40 minutes. Oh my God. You can't make this up. Judge Williams told the associate that she was not calling in her capacity as a judge, because she really was, but rather on behalf of her uncle, who was a respondent in a pending contempt action in Fulton County Superior Court, in which a partner at the associate's law firm represented the petitioner. So as opposed to her calling her uncle's attorney that worked in the law firm, she calls a separate attorney that's only been there like a second year there. So you're trying to screw her career up right along with yours because you care about your election. Cool, child, you can't make this up. At the time of this phone call, the petition for contempt was pending before Judge Kevin Farmer, who was Judge Williams' colleague on the Fulton County Superior Court Family Division. So, colleague judge, who still refuses to put her in check, because checks and balances exist for a reason, Judge Kevin Farmer. You could tell Judge Shermela Williams, you need to take a break. You need to go on vacation, like a 6-month vacation. All right. You need to clear up the cases you have and just take a break. You under investigation, take a break. This ain't working. What I'm reading in these complaints is disturbing to the average person. Because when you have a jury trial, the average person will be looking at this stuff. And everybody will be disturbed. No one is gonna say, yeah, this sounds about right. This is how you do court. No, the hell it ain't. Oh my God. Oh, Jesus Christ. All right. During the call, Williams told the associate that her uncle responded. What is the Her uncle responded was going through a difficult time. Judge Williams asked, never mind the young lady who was going through a difficult time that you unlawfully detained for 45 minutes, seeing her parents get a divorce because she has a strained relationship with her father, and you sitting here talking about daddy issues. So disgusting. That's nasty work. That her uncle responded was going through a difficult time. Williams asked the associate to agree to an extension of time for the uncle respondent to file her answer in the pending case. The associate then asked Judge Williams whether she was representing the uncle respondent. Williams responded she was not. So that's a no. So you're not the attorney and you're not a party to the case. They shouldn't even have stayed on the phone with you. Williams then stated that because the associate and others at her law firm were reasonable, they should work something out. Are you being threatening? Is this a threat I hear? Super City Girl Judge. Are you being threatening? They should work something out? Not could, maybe. You didn't ask to say pretty please? Oh, okay. You can't make this up. The associate told Judge Williams that the uncle responded, and this uncle responded, Courtney Beale, needed to direct his request for an extension to the court and send a written request to the partner at her law firm that was lead counsel on the case. During the conversation, Williams argued the merits of the case to the associate as if she's the attorney representing either party. Like this is ex-parte communication, but it's not because you're not even an attorney to the case or a judge on the case. So what are you doing? You're just running your mouth. Go eat some collard greens and go sit down. God, this is absurd. Now you see why cases like mine are sitting in an appeal status. Because it is. You don't know how to act. Good Lord, you suck. Watch out. Both parties should want this case to go to an appeal. So that both parties can say, at least we had a fair hearing this time. No. I gotta do it all by myself. But okay. Okay. Oh man. 2 days later, the uncle responded, made his own written request for an extension, which he obtained. Hold on, let me go back. They should work some out. That's the threat. The associate told Judge Williams that the uncle respondent needed to direct his request for an extension to the court, like file a motion for an extension, and send a written request to the partner at her law firm that was lead counsel on the case. That should go through his counsel. During the conversation, Williams argued the merits of the case to the associate, like she cared. Why did you care? You only care about your election. Now you care because it's your uncle. Never mind that young lady that was unlawfully detained because she didn't have a great relationship with her father, and you may not even know why. There could have been abused. How you know that? Crazy. 2 days later, the uncle responded, made his own written request for an extension, which he obtained. This is the nonsense of the buffoonery of this. Then it goes through many more cases where she just couldn't file orders in time. Y'all see what's bold in the black letters. That's the number of time that lapsed between the hearings and her issuing the final order. Because that's some lazy work. You just sitting on cases. Why are you having a hard time recusing yourself? You take everything personal, like a personal attack against you because someone is telling you to kick rocks. Get off the case. If you're going to take 30 months to issue an order, you should probably be like, one less thing to have to worry about. Bye. Bye, Felicia's. Bye. Y'all gone. You shouldn't even be objecting to it or giving anybody a hard time or trying to find ways to retaliate by saying, I'm just going to give custody over to the father because I don't like the mother's hoodie. Because you're deplorable. Unbelievable. Unbelievable.